Number 4. So what do you say is the number 4?
Yes, you can use it to watch on the notification control.
On the issues that council have raised, several of them.
Yes, starting with the submission of transfer areas for population. Worship has told court that we have failed to tell them how far we have gone with the investigation. However, your worship was very clear on this. Your worship, we are finalizing with the committee papers, your worship. And that shows your worship how far we have gone in this matter. Your worship, it's not true that we are laying this matter as council alleges. And we have used actually reasonable time in handling this matter, your worship. Your worship, council is trying to direct on how investigations should be done, which I think is not proper. The people conducting the investigations are professional and they know what they are doing, your worship. And as prosecution, your worship, we undertake to make disclosure at the appropriate time. And I think council knows all the procedure. All the necessary disclosure will be available to your worship. Your worship, in respect of blocking people to access court, your worship. Your worship, as prosecution, we are not party to this. We are not party to blocking of people. We are not aware that they were actually blocked from accessing court. We don't know the people behind it and the reason as to why it is being done, your worship. It cannot be put on prosecution. Maybe the relevant or the concerned people should be put to task as to why they are being so.
I wish you had consulted the DPP, the DPC.
Your worship,
when the minister corroborated the matter, why did you make an answer in the DPC?
Your worship, I don't know who is behind it. So I couldn't approach anyone without having notice of who is behind it, your worship.
And a matter of that nature be done in the district without the knowledge of the DPC.
Your worship, it has just come to my attention at this time that people were blocked.
That's why I am saying, when we have raised it, you should have been able to know where is the DPC from. You are not party to the blocking of the public.
No, your worship. And actually I wasn't aware that they were blocked.
So you think the council should address this matter before?
I think, Your Worship, we need to first find out who is behind it and why it's being done. Because I have no information about it, Your Worship. Your Worship, in respect of council, Ms. Your Worship has informed both that they have been able to produce the birth certificate from Linda Wilson, Your Worship. However, Your Worship, the document which has been availed to me is a birth notification report and not a birth certificate. Your Worship, you are all parents and we know that this document is issued when you go to apply for a birth certificate. And it is issued on the day you apply, you go for the application. Your Worship, this document was applied for on 13th of April 2026. It was applied for on 13th April 2026 when we worship this matter is already in court. So we cannot take it that whatever is reflected here is the truth, Your Worship. Your Worship, it would have been different if it was the immunization card or baptism card which had been presented. So I'll pray that this document not be solely relied on, and in that regard, Your Worship, I'll pray for a fresh, maybe re-examination to be done. A fresh examination be done, Your Worship, to ascertain his correct age, Your Worship. Worship Council has also said that Naburiman refused to accept Mwenda Wilson. Maybe the information I have got about that is that Nabu refused to admit him because there was no PF24 to back his age, and the only document which accompanied him was the document from where he was examined, and it showed that he was an adult, and that was the basis for refusing him. And that's why, Your Worship, I would pray for a fresh re-examination.
You started admitting because of what?
There was no PF24 showing that he was below 18 years. Your Worship, the only document which accompanied him was that of the examination which was done from Action Bay, and it showed that he was an adult. So they couldn't admit him on that basis. The premises, Your Worship, I will seek financial needs.
No, you didn't respond to some matter that number by already.
For example, Your Worship?
You talked about the date here, the home opportunity number 1.
Your Worship, all those are involved in the investigation, and we undertake to do disclosure to that effect at the appropriate time, Your Worship. Your Worship, that is part of the investigation.
The complaint is Mr. Kwabo that you've not had actually number 1 make a statement.
Your Worship, we have a statement for the accused person.
You need a statement.
Yes, Your Worship. And Your Worship, if they think that we are doing it in a wrong way, Your Worship, they can reserve that for their defense, Your Worship, to be clear, because it will be for their benefit.
What they are saying is that if you investigate the matter locally, maybe you will not charge. That's what they are saying.
Then Your Worship,
They are
that means
complaining
that
about lopsided investigations, and they are saying if you did start an investigation, maybe you will not be charging their two discussions.
Your Worship, I think the duty of charging or not charging is not for the defense counsel, Your Worship. And no one can be charged, Your Worship, without evidence, because the file is perused before any charge is being prepared. By the time any charge is prepared, there is evidence to that.
If it may please you, Your Honor, seeking indulgence that the first put the issue of birth certificate out of the way, then Madam Colleague will conclude. Yes, Your Honor, our short rejoinder is that the state submitted that we submit ignorant of the process, doesn't know the process. On the 10th date of April 2026, the mother notified as submitted by her an official document as proof of birth was issued on the 13th. So the notification is true. One of the processes was done ahead. But that original official document was produced on that. Public report. Yeah. And we pray that a submission be disregarded. And we reiterate that birth certificate or even notification by mirror is official communication to this honorable court as far as the date of birth is concerned. This court will not reopen this decision upon doubt that was cast on the report of the expert. The current alternative was ordered and directed by this honorable court. And believe this will satisfy this honorable court as to age.
Yeah, most families, you don't think the contents of the birth certificate will be different from the contents of the birth certificate. It cannot come when it is different from what is here.
Your Honor, if you check the official record, you will get that's the record of Mira. The record, official record of Mira as to age. That will not change. It cannot change.
Would you be doing of these two issues?
Not suspected.
Let me expound it, Your Worship. Just in the interest of justice. The purpose of this legal process, the spirit, the rationale, is for this honorable court to superintend over the matters regarding the investigations. So that by the time the committee is done, everything is exhausted. All issues regarding investigations are exhausted. Your Worship, if you looked at the provisions of section 168 of the MCA, once committee is done, the hands of this honorable court are tied as far as issues with the investigations are concerned. And the submission of the state is that if there are loopholes, and they have done it in a sloppy manner, then we take a benefit of the same. That is not the spirit of dispensation of justice. We are officers of it. We are not here to take benefit or take advantage of the sloppiness of the state. We are here to facilitate a process of arriving at the truth and ensuring that justice is done. That is our role as officers of the court. So it's the reason we are saying, Your Worship, as you are supervising the processes of investigations, that at least the statement is recorded from our client. Yes. It's not there. That's not true. Your Worship, we have said on several occasions we have put for record, midway recording the statement on the issue of the murder of the people at Mrs. Home cropped up and insisted that that line should be investigated. The process aborted. So there is no statement. It's a matter of concern, not only to the accused person and the co-accused, not only the people of Ogoye or Tanga, not only Ugandans, but humanity in general, that we get to the bottom of the matter. Who pulled the trigger and killed the 7 people at the home of Honorable Muwanga? I think it's a matter of great public concern which must be investigated. And we are ready to help in that investigation. It's not a question of preparing the committee papers hurriedly. Of course, we want to expedite the process. We need to have that as fast as investigated. Lastly, on that particular issue, the contention that the state has used to reasonable time. I think this is a matter which also needs to be addressed by this honorable court. What is reasonable under the circumstances, Your Worship? The incident we are talking about in this particular matter is alleged to have happened on 14th of January. The charge sheet was prepared on 30th of January. Today is 14th April. That is a reasonable time, and no progress has been made. That reasonable time. I must applaud the DPP and the state for that matter in the case of the Gaba daycare murder. The accused person, Your Worship, if you have taken judicial notice of the state, the accused person is presented today. The following day was committed. Today, the matter was put for mention. The following day, committed. And the trial has already started. In comparative terms, when you look at the proceedings before you, ever since you started appearing, what has happened? Nothing. Nothing. We come. It is that done. Even these 2 weeks they are asking, it will be the same story. I'm sorry, with all due respect to my sister. When we come back here, we say, there are a few things we need to fix. We are yet to finalize. Give us more time. And the accused person is continuing to rot in Chicago. And it was that. And of course, the children remain home in Laba. That is a violation of the letter and the spirit of Article 28 of the Constitution. which should not be condoned at this matter. Regarding the third issue, Your Worship, about the second issue of blocking members of the public from accessing the services here. The state cannot run away from its obligation. No. The state cannot run away. The representative of all the agencies before court, the agencies of state, is my dear sister here. She's an embodiment of the police, embodiment of UPPF, embodiment of SFC, all these security agencies that handle matters to do with criminal investigations and prosecution and handling of suspects and what, not even prisons authorities. This is the state. And the face of the state is my sister here now. So Your Worship, this is a very serious matter. The Article 28 was not made in vain. Why the hearing should be made public? It was not made in vain. It is derived from the principle enshrined in Article 28, or rather Article 126. If I may read Article 126, my Lord, for emphasis sake. Judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with the law and with the values, norms, and aspirations of the people. So, Article 126 emphasizes that point that whatever is done by this honorable court is done in the name of the people and for the people. And therefore the people should be allowed to witness whatever is happening. Actually, it is the spirit behind this new phenomenon of mobile court, as it was elucidated by the Chief Justice. So, Your Worship, the environment we have here, the public is not allowed to witness what is happening. It's not conducive for administration of justice. And my dear sister here cannot just simply talk about it in a cursory manner. Your Worship, if I may disclose to you, in some of us here, we feel in such a way when we are here, we feel you are not comfortable to freely exercise your duty. If you may look at what is happening with the window lens. I'm serious. Look at that gun which is placed in it. It has clothing. It's the first of its type. I've never seen it in my life. That is dressed like a human being. So it's a matter of it is dressed like a human being.
When it is dressed like that, it means it's not going to be ready. It's not going to be applied immediately.
So, Your Worship, this is what is making us feel very uncomfortable in this kind of environment. And I'm glad, Your Worship, as I conclude, my sister has not objected to our prayer to have a mobile court, the home of Muwanga Kivumbi. She has not objected to that, to the prayer we made. Like in the proceedings in Ghana. Very interesting. We are all following what is happening there. The public is seated in the tent there. They are all witnessing what is going on. I wish it would happen in this case that we are seated at the home of Muwanga, at Bugoye, and then we have the proceedings conducted from there. so that the public is witnessing what is happening as their power is being exercised by this honorable court. So we do so pray, Your Worship.
Your indulgence, children, students, we emphasize the necessity of a clear path also on the ground, and finding that we have children who were arraigned. Many of them are school-going children, Your Honor. One actually, Wilson Muyinda, has just passed his O-level with a high recognition by a school pending admission in HSC. High recognition. He got 6 B's, 3 C's, aggregate 18. He's the youngest. This group pending your findings. So it's such compelling reasons why we believe there should be a clear path. We have students here school going. So that we know whether even by the time probably they may decide to drop charges against some, as the any reasonable person will do in the state. Probably they would have lost, yeah. So that is why we deliver on that issue. Your Honor, again I rise in Muwanga Court. Muwanga Court was found to be at least below 18. The law commands that this honorable court should guide what is in the best interest of the child, the best interest principle should guide the directions of this court.
What you want us to do, the rest of the children are going to
Your Honor,
Number 19, I want to. What do you want us to do?
no, Mom, I have specific prayers, but I want you to be orderly after hearing when you're finding on the schedule, so that I will proceed jointly on them. Unless there are applications that we shall make. But we're not all over the place.
You want me to make a finding about the area?
No, on whether this is sufficient, whether that.
And I wouldn't have a problem with it. Because my view is that the combination that the certificate was to be produced, it wouldn't differ, the content wouldn't differ from what is already.
At this moment, I wish to make my application. Wilson. Again, I wish to inform this court that apart from him being at police as we speak, even the cost of him being brought here are borne by the parents on border. This for the background against which I wish now to make an application which can be clear on where he should be. That should be with his parents. I premise this application section 135.
Your
Application.
Your prayer is what?
I'm making an application for bail so that it is determined where he ought to be. That is with his parents, not at police. The application for bail is premised on section 135. of the Children Act, Cap 62, and paragraph 17 of the Judicature Bail Guidelines for course of judicature.
Paragraph what?
Paragraph 17. Brackets, bail guidelines for course of judicature, brackets, close brackets, then bracket practice, bracket directions for 2022. These provisions mandate this honorable court, for which Linda Wilson has appeared, uphold, it enjoins this court, uphold his right of applying for bail and being admitted to bail. Our understanding of this law, any court includes the magistrate's court, though a capital offense, it can hear and determine the bail application for this child. Brevity guidance. Section 135 states that where a child appears before the court charged with an offense, the magistrate or person presiding over the court shall inquire into the case, and unless there is a serious danger to the child, release the child from bail, A, on court bond, or the child's own recognizance, B, with sureties, preferably the parent or guardian of the child, who shall be bound with a non-cash court bond. Your Honor, before you, we have the mother of Linda Wilson. Nanteza Salima, and his paternal auntie, Nasazi Rebecca. The mother, Nanteza Salima, is 38 years old. The mother to the 17-year-old is 38 years old. A resident of Wamala, Nansana. She operates a salon at the home premises. As national identification card. All these details.
ID card is number 1.
ID is number. It is number CF 87026107 U2QH. I have an original copy. Vote. It clearly states the residence. To submit that she qualifies under 135B. The second parent, Nassaz Rebecca, is 43 years old. This one has a copy of her ID. F 830 801 801 00 LYWA. She has a copy of the cell. Now this one lost the original, that is the copy. She has letters. Yes, and actually voters identification slip. She submitted all this. I will pray that you find that he is qualified under paragraph B. He's seeking your compassion. The child. Put him in the right place. And not for this intention where he is. Secondly, I wish to note, Your Honor, that quote and note that he is a student in St. Mark's College, Magoma, the school going child, S4. We have just completed S4. The results of public record are that is qualified. That will get meeting, join HSC. None of all this should inform the judicious discretion. That meeting. You and I, they in the hands of his parents. So I've explained to them what this means, both parents. That they should ensure that whenever it is required, he attends this court. To understand the same, your inquiry as the law guides Your Honor. Within the family. We submit the child cannot be any secure in any hands but those of parents. The issue of security, we submit that there will be secure hands within their parents' hands at Wamala in Nasta. Any other issues that will be guided by this court. It is so. This is the most obliged.
This is the respect for the
Of wisdom. And since they are here, this court is quite obliged. Your Honor, in respect to Mawanda Paul, first, let's be on record. Mawanda Paul has complained about the feeding in Nakuru remand. For him, it's actually in his own words. It's even worse than the prison where he came from. He has complained about conditions in Nakuru, one home. He has added more further information to this honorable court for purposes of reapplication of bail. The grounds, the reasons for denial were that the situation is still volatile in this locality. The owner actually did not have the information at the time. We submit that Mawanda Paul actually is a resident of baleeteddwa. Bomba is outside this constituency. It's outside this district. That's the problem we have with the age was wrong. As I'll submit, he still lives with his parent, literally his mother, Nankija Susan. Nankija Susan's national ID, the record is very clear that she is from Gomba. The record will be very clear still that this juvenile was arrested even before the election. If it's about the election date, he was arrested on the 14th date of January. While in town. What in Bulo? Not at the explosive scene of the 15th or 16th. As I said, the national ID is very clear that the mother with whom he stays is from Gomba. The mothers produced her national ID, valid NINCF 8709 110 39 V 1C. Is before this court. She's 39 years old. She operates a restaurant. Told me where you occasionally in Bomba. For sure, for you to convince you, if admitted, that would wish away the constitutional protection of a child, and admitting him to bed, the almost obliged. You know, with a child, someone just wants to do that be a mother. That's what I'm saying there. The issue is about mother. If someone qualifies to be a parent, someone has to be placed in hands of the parent. That is the qualification that I've seen. I'm sorry about mother. Very well for you. The parent, that is what they would be. And that is why the court is enjoying it. We inquire. It's about safety. The hands where the nation is being. It's not ours, but the adult. If you look at these provisions and the provisions of bail, you will find that they differ.
How would we know that she's the mother of this boy?
Yes, that is the inquiry. That's good.
Because I never see that I will do that.
That's why court sets conditions. We don't oblige the condition upon the investigation of what is required. We don't oblige the condition of grant in whatever we can produce.
Actually, it's true under section 155 of the Children's Act, they have a right to apply for bail. However, Your Worship, I do object to the application. Your Worship, in respect of F1, that is before that is Moyinda Wilson. Yoshi, he said he's still in contention. Yoshi, I still contend that a birth notification record is not a birth certificate. And it cannot be solely relied on to prove his age, Yoshi. Your Worship, secondly, they are saying that Moyinda Wilson is a student who finished his senior form. I don't dispute that. However, being the fact that he sat for senior form, I think a pass slip would be more relevant, because it usually indicates the age of the what? Of the person sitting exams, Your Worship. I'm not sure whether they are out now, but it would serve more purpose, Your Worship, because it usually indicates the age of the candidate, which, however, it hasn't been provided. Your Worship, in respect of the sureties presented, they are all residents outside the jurisdiction of this honorable court. Your Worship, they haven't provided house letters which would guide court to establish whether they are actually the biological parents of these accused persons. Your Worship, in case these accused persons are released and they don't appear in court, in case these accused persons are released and they don't appear in court, it will be very hard for us to trace for them, since we don't know the LCs where they reside, Your Worship, and since we haven't known whether they are actually the biological parents of the accused persons. The thing says, Your Worship, I pray that the bill be denied and matter should be achieved. So good.
Your Honor, briefly, she said she's a mother. Yes, that is very key in this. We are producing parents, and she's on record having parents. So she's serving the public. The ratio here, we don't think anyone should give a child. I don't believe anyone would prefer to keep a child in custody, save for serious grounds. The requirement of the law is she has to prove that there is serious danger, because hers is not just convict a child. It includes protection of the right as the state of the child. It represents the state, which has a cardinal duty. And I don't believe those are high instructions from the state. They are her personal submissions, because the state is enjoined to protect the child. She's being unkind. Your Honor, as to proof of birth, this court has already made its finding, but I'll add, proof of birth is either by birth certificate, baptism card, immunization card, national ID, or passport. But the best evidence, official record, is the birth certificate. But I will rest that case. I will not reopen. We were guided by the Supreme Court. Because even a statutory declaration, that's why she's here before you. Her declaration to the public and to you, a statutory declaration in the investigation inquiry before you would suffice. Unless rebutted. She has not submitted on that there is fear or danger to the child. And that's the requirement. Your Honor, as to parentage, an LC letter is not proof of birth. It does not fit. It is a hangover of the bail application for the adults, which is ordinarily objected to. This is mainly a preserve of the court to save the rights of the child. Unless she wants this court to order a DNA test, which would be out of it. It would be high-handed. Your Honor, once this honorable court is satisfied in the circumstances of the case, the child may be safe in the hands of the person presented as parent, may admit the person on bail with or without an LC letter. It goes without saying, being a child, she has no national ID. He has no national ID. Neither does he have a passport. We will reiterate our prayers, seeking the benevolence of this honorable court to the child. Admit them, both Africans and they are most okay.
Mr. Muwanga, let me take time to consider and pronounce myself on the 28th. As for the data application, let me come back.
Alright, wetwendera cyane.
Yatuzania
Wow. Right, wetembera weri wano ku kooti mulungi atulaba ku JP Muwanga mulungi atulaba ku Uganda Media One mbeera bwetyo weri wano ku kooti ebatambala akaseera kano omulungi atulaba era obwedde atugoberera omusango guno gukyagenda mu maaso byonna nga bwe mubiwulidde ate tumuvaako tugenda kuba nga tubawa so babe nga ate babanyonnyola biki ate bagenda kubanga bazaako ki mu guno omusango mbeera bwetyo bweri gwe mulungi atulaba wano ku Uganda Media One naawe atulaba ku JP Muwanga naawe atulaba ku Lukirio TV bwetyo embeera bwekyali okulaba nga tubaweereza buli kimu tuli wano ku kooti Butambala omulungi atulaba akaseera kano gwe ali ku JP Muwanga tukwebaza bwebaza naawe ali ku Uganda Media One naawe ali ku Lukirio TV bwetyo embeera bwekyali okulaba nga buli kimu tukibaweereza wano mu kooti Butambala. Tukyali ku kooti mulungi atulaba akaseera kano okuba nga ate buli kimu kikyatambula mulungi atulaba akaseera kano. Alright, mulungi atulaba akaseera kano bitembeera bukyali kooti eyimiriddemu obuyimirizi katono nnyo era tugenda kubanga buli kimu tukibawa omulungi atulaba kooti eyimiriddemu ate tugenda kubanga era tubaweereza buli kimu ekifaanano kooti eyimiriddemu okwo era tugenda kuba nga tubawa mugendereko mugoberere mugenda kuba mufuna final results.
nange obulamu obulina fena nnyo nnyo nze nali wano mbasomye kubamanya obulina kasina transport nzirayo mpaka basibe olera muwanga Kivumbi afana kusente naye kamberekereze akambe yakuda coaching ezeemwe tujja kuda kooti ezeemu.
Alright, omulungi ndaba kamunzikirize nsooke nveeko okwo katono nnyo. Ngenda kukomawo okwo nga kooti ezzeemu. Ngenda kukomawo nga kooti ezzeemu. Omulungi ndaba ku JP Muwonge, ndaba ku Uganda Media wano, ndaba ku Lukirio TV. Wendi okuba nga mbaweereza buli kimu naye munzikirize nsooke nveeko ngenda kudda nga kooti ezzeemu.